All right, pulling it back here. Of course, we're continuing our coverage of the breaking news. The Supreme Court has ruled that former President Donald Trump should appear on the ballot in Colorado. The decision comes after debate over whether the frontrunner for the GOP nomination violated the insurrectionist clause included in the 14th Amendment. So Derek Muller is a professor at Notre Dame Law School, and he's joining us now. And CBS News election law contributor David Becker is also joining us to kind of break it down. Hopefully you guys got a chance to peruse the decision, but it says it all really on the first and second page.
Right.
Derek, how did the court come to this decision, and how did the court decide that Section 3 of the 14th Amendment does not apply to this case?
Right. So it's important to think about a couple of things. The first is that the court didn't really get into the weeds about whether January 6th was an insurrection, whether Donald Trump engaged in it, and instead focused on a structural issue. Can states enforce this mechanism, this provision of the Constitution in their ballot access rules? And for a majority of the court, they said that states just don't have this power. It is really left to Congress to make the determination about how it wants to implement and enforce this provision of the Constitution. So there was unanimity on that point. There were 9 votes for that point, but there was a little bit of dispute. And 4 of the justices disagreed with whether or not Congress has to do this by legislation, whether it's by specific mechanisms, whatever it might be. And maybe we can get into the weeds of that, but there was unanimity. All 9 justices agreed states just have no power to enforce this on their own. It's something that needs to be left to another actor in another stage of the political process.
So, David, one of the, when I'm looking through here, it says that the court should put a swift and decisive end to these ballot disqualification efforts, which threaten to disenfranchise tens of millions of Americans and which promise to unleash chaos and bedlam if other state courts and state officials follow Colorado's lead. And yet, as we've been discussing, the Supreme Court did not weigh in on whether or not January 6th was an insurrection. So the question that I have is the one that Tony DeCoppel asked during the special report, which is, will President Trump, and I know that we can't prevent him from doing this, but will he use this as the basis for saying that he's exonerated of everything that he's been accused of?
Yeah, I think obviously we can't do anything about what President Trump may do in his campaign, but you're quite right. This does not get former President Trump to the finish line. It just gets him to the starting line. This just says that he can compete in the political arena to win the presidency again, because states cannot keep him off the ballot, because states under a blanket rule, as Derek mentioned, cannot act absent congressional action to remove federal candidates from the ballot. That's what this decision says. We should remember that as the ballots exist right now in states like Colorado and Maine, and even Illinois, which just last week disqualified former President Trump from the ballot, he's still on those ballots. He's on those ballots, and it just means that those ballots will be counted, those votes will be counted, and delegates will be awarded as appropriate. But in some ways, this also could lead to challenges down the road, because one thing all of the justices apparently agree on is that Congress does have authority in this area under Section 3 of the 14th Amendment. And that means that should former President Trump win the election in November, this could come up again, particularly on January 6th during the joint session of Congress.
Derek, this kind of reminds me of how we thought about the Supreme Court maybe a few Supreme Courts ago, if you will. Like, you know, I always, considering the widespread impact of a decision is the way I always thought the Supreme Court sort of looked at many of these cases. Right. But then with, you know, Roe v. Wade being overturned and stuff, it seems like that's no longer kind of the tradition of the Supreme Court. So I want you to kind of weigh in on my really rudimentary observation that this reminds me of the court the way that it used to be.
Yeah, I mean, the court is always thinking about the practical concerns and the operation of its decisions, right? When it is the United States Supreme Court, it realizes that it is speaking with precedent that will bind state courts and federal courts throughout the United States. So there's no question that it's trying to speak on an issue with some clarity and to provide some guidance. And I think, you know, when the court is fracturing a little bit in some places here on the implementation. There's no question that a majority of the court here is looking to say we want to resolve this question, say it is not for states, it is not for any other process except by the mechanism that Congress wants to set up for us. And if it hasn't set up a mechanism, if we don't have that congressional implementation of Section 3 of the 14th Amendment, states, you can't do this on your own. So in a degree, it is providing that consistency and guidance for the United States as a whole.
And so, one of the things, David, that I think is for the people in this country, for people who are going to go to the polls, in a way, to the point that Anne Marie is making about the unanimous decision of the Supreme Court justices, both liberal and conservative, I think most Americans, even if you don't like President Trump, you don't like what he represents, you don't like his politics, you don't like his policies, you don't like the man. But I think most Americans would say, look, beat him at the ballot box and don't try to use a state and a state's Supreme Court to try to remove him from the right of Americans to vote for who they like for president. Especially since the Supreme Court did not weigh in as to whether or not the former president engaged in that insurrection in the way that Colorado did.
Yeah, I think the American people, and of course the courts, have an understandable resistance to removing people who might otherwise be eligible to run for office. Now, we have qualifications for office in a variety of contexts. President Obama or President W. Bush couldn't run for re-election. You have to be at least 35 at the time of the oath of office to serve as president. But this was one of those that was more in a gray area. And I think it's understandable that there was some reluctance to remove an otherwise eligible candidate for office, even if he might have been perceived to have engaged in insurrection in violation of the 14th Amendment. But we should note the court did not address that at all, did not look at the factual findings of the lower courts, did not look at whether or not he was an officer of the United States who engaged in insurrection under the 14th Amendment. So it is not an exoneration in that sense. It merely means that Congress did not set up a framework by which the states could remove a federal candidate. And for that reason and that reason alone, no state can remove a federal candidate absent congressional action. So this should put an end, barring some congressional action, which I think is exceedingly unlikely, this should put an end to these ballot challenges for the foreseeable future.
But Derek, David raises an interesting question. So what if we, and I know I'm speculating here, but I'm just trying to understand why the court would not look at the findings of the Colorado Supreme Court, so that if we were to find out that former President Trump was 34 and not 35 years old, that would be something that the Supreme Court would look at, right, and say, well, the findings reveal we've uncovered his birth certificate and he's actually only 34 years old. So that means he can, in that case, they would remove a candidate that perhaps a lot of people want to vote for from the ballot. So why not, beyond the scope of just looking at the third clause of the 14th Amendment, say we've also looked at the findings?
Yeah, so again, the court is really trying to focus on the issue before it, which is only Section 3 of the 14th Amendment. I've written about these issues and said states have kept 21-year-olds off the ballot. They've kept Nicaraguan nationals off the ballot. What makes Section 3 different? And there's a few different things going on in the opinion. And I'll start with Justices Sotomayor, Kagan, and Jackson, who wrote separately in the opinion to say, look, we don't think that this provision of the Constitution was designed to empower states. And so it's very strange to think about this provision, which is actually designed to restrict states after the Civil War, after a bunch of states had seceded. There's something unique about this provision. And for the majority, they would look at it and say, this is really about congressional power, congressional judgments, congressional enforcement legislation. And when you're dealing with a presidential candidate who can give this who affects all 50 states, right, to allow one state to make this determination where it's contested at issue, maybe 34-year-old is not contested, but whether someone engaged in an insurrection, without Congress helping us figure out who engaged in an insurrection, whether or not there's a problem, whether or not somebody has been found liable, guilty, whatever it is, it's not up to one state to do it. Congress needs to set the rules here.
Fascinating.
Yeah.
Derek Muller and David Becker, as always, we thank you very much for your analysis. Appreciate it.